If you agree, I'm not gonna come into your homes and interfere with your agreements. But if you can't agree, I have to make decisions that I think is in the best interest of your 5-year-old child. Good morning, this is the time set for case D. If we could have counsel with your parents first.
Good morning, Your Honor. Richard Schonfeld appearing along with the plaintiff. The defendant and proper person.
All right, and first of all, a few housekeeping items. I want the record to note that Ms. did have the opportunity to meet with my law clerk and review the psychological reports from Dr. Holland, right?
Correct.
Okay. And then also, we have on record, on schedule, hearings on October 6th and October 13th, which are really both related to the parenting coordinator process. On the October 6th hearing, I'm going to move that to October 13th so that I can hear that. I won't be here the week of October 6th. So that, I know that the plaintiff filed her opposition and exhibits yesterday. Right there, no, the defendant filed his opposition and exhibits yesterday. So everything will be heard on the 13th. I'm also going to order the striking of the supplemental exhibit filed by the defendant on August 26th, which is item number 178. Sir, there is no authorization to file supplemental exhibits, so I'm striking that from the record. Now, with regard to the two motions and counter motions that I am hearing today, I have reviewed everything and I'm ready to make findings and orders. I believe both of you also received the order I entered for media access.
Yes, sir. Yes.
All right, so with regard to plaintiff's motion for clarification and enforcement of vacation time, the court finds that the court tried to enter a clear order regarding summer vacation, but with the limited time that was left this summer after the trial and the high conflict over every single issue regarding raising your child, that the court should have just designated dates for your summer vacation for 2021. In high conflict cases such as this, it is recommended by experts that parenting plans be highly structured with clear orders to avoid parents having to negotiate and or get into power struggles over every issue. It is also in the best interest of your child that the court does this in this case. Also, it is the best practice to have a separate attachment for holiday visitation. So that's what we're going to do in this case. I'm going to enter a new holiday and vacation schedule order. The only changes I'm making is going to be on the summer vacation. And I wanted to clarify, Mr. Schonfeld, what day did Dad return the child to Mom from summer vacation? Was that on the 11th, 12th, 13th, 14th? 14th.
July 14th, Your Honor.
Okay, July 14th. All right, so what that means is Mom's motion to clarify summer vacation is granted in even-numbered years. Dad's summer vacation shall begin at 3:30 p.m. on the first Friday in June and conclude at 3:30 p.m. on the fourth Friday in June. Mom's summer vacation in even-numbered years shall begin at 3:30 p.m. on the fourth Friday in June through 3:30 p.m. on the Friday 3 weeks later. In odd-numbered years, Dad's summer vacation shall begin at 3:30 p.m. on the third Friday in June and conclude at 3:30 p.m. on the Friday 3 weeks later. Then Mom's summer vacation in odd-numbered years will begin at 3:30 p.m. on the Friday that Dad's vacation ends and conclude on the Friday 3:30 p.m. 3 weeks later. To be even more specific, the next two summers, the vacation dates are as follows. 2022, Dad will have summer vacation from 3:30 p.m. on June 3rd to 3:30 p.m. on June 26th, and Mom will have vacation from 3:30 p.m. on June 24th. I'm sorry, I may have misstated the date. Dad's summer vacation in 2022 will end on June 24th. That's 3 weeks. And Mom will have summer vacation from 3:30 p.m. on June 24th through 3:30 p.m. on July 15th. In 2023, Dad will have summer vacation from 3:30 p.m. on June 16th through 3:30 p.m. on July 7th. And Mom will have summer vacation from 3:30 p.m. on July 7th through 3:30 p.m. on July 28th. Mom is entitled to 3 days of makeup summer visitation, which means that her vacation in 2022 will actually conclude at 3:30 p.m. on July 18th. That's a Monday. With regard to this motion, the court is not going to award attorney's fees and costs to either party, and I am signing a brand new separate holiday and vacation order so you guys can have ease of referring to it in writing. If the parties have the ability to cooperate and negotiate, we could leave it that way, but every single issue is a fight. I'm surprised you haven't fought over what color hair your son should have or what his haircut should be. But, and the parenting coordination process is obviously not working to make that any better. But that's the ruling on the summer vacations. Now, there's a lot packed into Dad's other motion that is set for today. He called for an order to show cause and for a new trial. So I'm going to go through each separate request he's made and the legal standard for each requested relief. On the order to show cause for contempt, the court has to deny that motion. First of all, and very basic, Dad's motion does not include a detailed affidavit as required by AWAD that should have outlined each order and each alleged contempt. That's a prerequisite and jurisdictional requirement on contempt. The defendant has also not established the elements required for contempt, which include a valid order, notice of that order, ability to comply, and willful violation of that order. There's no order applicable, and those elements are found in the Cunningham case. With regard to the request for a new trial, NRCP 59, subsection little a, subsection 1, states forth the grounds that a party can request a new trial. The court finds that defendant's new trial motion is timely, given when the finding of fact, inclusion law, and decree of custody was entered in this case. However, the court must deny that motion because defendant does not establish one of the grounds for a new trial. Under the subsection capital A, there's no irregularity in these proceedings that would require a new trial. Subsection capital B, misconduct. Defendant has alleged that plaintiff committed perjury regarding some text messages that were admitted into evidence at the trial. The problem is here that there's no admissible evidence of perjury. There's too many ways to manipulate text messages, delete text messages, create text messages out of thin air, and any forensic preservation of messages should have been done prior to the trial. No way now to prove whether the messages were deleted or fabricated to any reasonable scientific certainty in this case because there was no forensic preservation done by either party. Relatedly is subsection C and D. First of all, the court finds that there is no accident or surprise here. The text messages were timely produced by the plaintiff, and the plaintiff also requested through formal written discovery that defendant provide text messages. He did not provide the text messages that he now attaches to as an exhibit to his motion. Plaintiff can just as easy claim that defendant created fraudulent text message records because when she asked him for them in discovery, he did not produce these records. Defendant had time and did conduct the deposition of plaintiff, and he could have asked her about any of those text messages in detail at the deposition. Similarly, there's no newly discovered evidence that defendant could not have produced and used at trial. He had the opportunity to cross-examine the plaintiff at trial about each of these text messages. He had the opportunity to provide his own text messages at the time of trial. Also, even if the plaintiff was wrong about the dates of some of the text messages, not material to the court's decision. The court also finds that subsections E, F, and G do not apply to this case. With regard to defendant's request for relief from judgment or order pursuant to NRCP 60 subsection little b, the factors that might apply to defendant's motion overlap in some ways with the new trial factors in some respects. The court finds with regard to the subsections that might apply that there is no mistake, inadvertent, surprise, or excusable neglect in this case. Again, defendant had adequate time and discovery tools available to fully review the authenticity of plaintiff's text messages, the timing of those, and her testimony regarding them, and made choices in discovery and what he was going to provide and not provide. Same thing with regard to subsection 2 regarding newly discovered evidence. Obviously, that does not apply in this case because defendant filed a timely motion for a new trial. 60B, subsection 2, only applies if the newly discovered evidence was discovered after the time deadline for the new trial motion under NRCP 59B. With regard to the third subsection, fraud, misrepresentation, or misconduct, that also overlaps with NRCP 59A 1B, and there is no admissible evidence of fraud, misrepresentation, or misconduct. It comes down to still, especially with the way the discovery was conducted in this case and the providing of the text messages by defendant well after the trial, that there's just no admissible evidence here. Even the program he used states it's not forensically reliable and not to use in court. The court finds that subsections 4, 5, and 6 do not apply in this case, as well as 60 subsection D does not apply. With regard to changing the order regarding school, the court could consider that, based on when it was filed, a timely motion for reconsideration. This issue was just litigated at trial in May and through briefs in June, and the written decision was entered by the court on July 1st, 2021. There has been no change of circumstances since July 1st that warrants reconsidering school selection for the 2021-2022 school year. With regard to the proposition that your child should attend Foothills Montessori, the court is specifically troubled regarding that. There are deadlines so that things are not conducted by surprise. There are certain deadlines for things to be provided. Foothills Montessori was never suggested by the defendant at the time of trial, nor in his brief regarding that the court was kind to the defendant in that he failed to provide any evidence or any proposals at trial regarding a school in Clark County. Gave you the opportunity to provide a brief because of the way that trial issues were done, to provide a post-trial brief on that issue. You filed that on June 8th, 2021, and Montessori was not even mentioned. The court also is troubled that you complain about the distance and the commute to the school that was selected, and that Foothills Montessori is even farther away. Lastly, the cost. If defendant can afford this expensive private school, the court may not have imputed enough income to the defendant. With regard to defendant's request for an injunction for possible fees, the court finds there's no merit to that request, given that I'm denying all the requests in defendant's motion. It is plaintiff who's entitled to an award of attorney's fees and costs from plaintiff's entitled to an award of attorney's fees and costs from defendant pursuant to EDCR 7.60 little b and NRS 18010. The plaintiff will have until September 27th to file a Brunzell affidavit and a memorandum of fees and costs with billing statements attached and serve that on defendant. Defendant will have until October 4th to file any written opposition to the amount requested by the plaintiff, and the court will render a decision either at the October 13th hearing or sooner on that issue. So to be very specific, I'm going down the requests the defendant set forth in this motion filed on August 16th, 2021, so we have a clear record. The order to show cause is denied. The request for a new trial is denied. The request to set aside the findings, fact, inclusion, law, and decree of custody under NRCP 60 is denied. The request for homeschooling, oh, that's the other part. Yes, the homeschooling. The court finds in this case it is absolutely detrimental to the minor child's best interest for these parents to try to homeschool. Homeschooling requires when you share custody, requires a very high level of communication, cooperation, and being on the same page and having the same philosophy regarding education. That would be completely detrimental to the child's best interest. So I'm denying both requested orders on the school for the minor child, denying the request for injunction, and the request for any attorney's fees for the defendant, and I'm granting the counter motion for costs and fees to the plaintiff. All right, sir, since this motion is your motion, I'll start with you. Do you have any questions or clarifications regarding the court's ruling and order?
I would just say that in terms of being prepared for, in discovery for the messages that plaintiff presented, that the messages had no dates, and she could have, if they had no dates and they had a little d as the sender at the top. And I don't know how it would be possible to prepare for whatever she's going to claim that those are. The other thing is that the phone still exists with the messages on them. And I guess my concern is, how would anyone ever prove inceptive fraud in text messages? It seems like, how can we have it both ways if someone's going to testify that they are certain that they know the dates of these text messages? Those are going to be admitted into evidence, and then we're going to find out later that they don't exist, and that some of them are confirmed to be on the wrong date. I mean, it seems just like that.
Now, sir, if you want me to answer that specific question,
Sure.
The answer is you could have done the same thing you did apparently after trial and extract all your messages. You could have done the same thing before trial. You could have produced it in timely fashion as to the plaintiff's request for documents. You could have asked her about every text message that she had provided at the time of her deposition. You could have cross-examined her at trial. You would have been able to have those extracted. You can't do that after trial because you had the opportunity to do it before trial. You could have questioned her on the authenticity of any of the text messages she wanted to use in trial, as well as her testimony regarding the dates.
She submitted the text messages after her deposition.
Okay, you could have then taken another deposition in time. I know this trial got continued more than once. This case has gone on way too long.
I mean, it just seems like the strategy for someone would be to inundate someone with discovery, which is what happened in this case, and then for them to, realize that the other person's not going to make it through all these text messages, especially when some don't even exist. I just have no idea how to prepare for that.
Okay. Well, you had very experienced counsel in helping you with the discovery and preparing for trial, and you made strategy choices, as every party does, especially when you have limited time to present evidence at trial. You made strategy decisions regarding what you're presenting, because the other point of plaintiff's opposition that she's correct on is, even if everything you say is true, it's not material to the decisions that I made, and the findings of fact was based mostly on both of your testimonies and both of your behaviors, and a lot of the, as she pointed out in her opposition, a lot of the text messages, you agree that they exist.
Right, but they
The
were
timing of them was different, is your allegation.
correct.
And she's admitted some of them, yes, you were right about the timing, that her estimate of the timing was wrong. I find that that wasn't material in terms of the difference in time and in terms of just the big picture of the impressions regarding both of your abilities to co-parent.
One of the most important findings in the case was my text messages to plaintiff at the time of the breakup.
At the time of which breakup, sir? Because
At the
you
time
guys
of the
broke
final
up
breakup
many times.
at the time of the final breakup was in the written findings, which seemed to lead to a conclusion that it was my intent to punish her if she wouldn't remain in a relationship with me at the time of the final breakup. So the timing of the text messages seems very material and substantial, as well as just the general attempt to create inceptive fraud, especially when we still have the exact phones. I mean, the forensic evidence does exist.
forensic evidence wouldn't be able to tell if you deleted the messages that she still has. Wouldn't show that.
I'm not certain, but I would think that the metadata on those things would show that. And again, I appreciate you hearing me out.
If you had them forensically, but you had the opportunity, that's the problem. You can't do this after trial and say, well, but I also will state to you, even if I didn't make that finding, I would have still made the same findings regarding your request to relocate and regarding your request of primary custody. Most of the issues in this case came down to you two having a complete inability to communicate adequately and to cooperate and co-parent. So that's where it came down to, and even if those text messages weren't entered at all, I would have still made the same finding on that ability to communicate and cooperate between the two of you. And if you can't communicate and cooperate and co-parent with her, you can't move your child across the country from the other parent.
Okay. I appreciate you hearing me out on that part. On the motion to modify school choice, the change of circumstances were that plaintiff provided several material facts about the schools in question in her memorandum and did not attach an affidavit swearing to those facts in the memorandum. And then the court made findings upon those facts, which were not sworn to and which were subsequently incorrect. Namely, the student-teacher ratio, she claimed was 17 to 1 or 19 to 1. It's actually 30 to 1. Masks have since been implemented at the school. The distance is different than she claimed. And I also submitted the messages about plaintiff wanting to suddenly take all the weekdays. And it just seems like it's an attempt to backdoor relocation and primary physical custody because of the length of my commute.
So there's no backdooring anything in that regard. It's not materially far from you where she moved. She didn't need to file that. She testified at trial. Remember, she had all her evidence in a row. I could have made a decision on that day. I gave you the opportunity. Again, you're coming late to that time limits. You don't seem to understand those. There's deadlines for everything to be decided. Had you come in at trial in May and said, I can afford Montessori Foothills, this is a great school for our child because of X, Y, and Z, it might have been a different outcome on the school. But you didn't even present that in the brief.
But I didn't know that we were litigating school choice at the trial. I mean, that's no excuse, but.
That's why I did give you, because of the way you set up your case, I gave you the opportunity to talk about what school choice I should consider for your child, because it is about the best interest of your child, and the options you presented to me at the time means that I decided the school I decided.
Okay.
And that's going to have to, and masks are everywhere. We've been doing a lot of litigation about schools and the fact that most children do not thrive on a homeschool or online setting, especially young children who need to learn hands-on. They need to put their hands on things, manipulate things to learn, to be able to interact person to person with their peers and learn how to behave in a social setting. Online school is not working for 90% of the kids, 95% of them. So, but we have to have the alternative because we're in this new world of COVID, is that we all have to wear masks, and it's not 100% great. But it's better than the alternative of being sick or the alternative of trying to do online school. You and the plaintiff do have the benefit of being self-employed and setting your own work schedules. So you can do more than a lot of parents have been able to do, and you did do a lot for him for kindergarten. He's prepared for first grade, he's in first grade. Some of the things you said in your motion just aren't true about him being in first grade and those kind of things.
I'm sorry, I don't.
They weren't accurate when you made the allegation that he wasn't put in first grade.
He had to test into first grade. They did assessment tests.
And he would have any which way because of the birth date. Right? And the way it was conducted. He could have been in kindergarten this year. You guys could have held him back.
Correct.
And put him in kindergarten.
And again, I see that as further evidence that homeschooling did work, that we were able to prepare him for first grade, but
it's going to be a big fight. And I'm being very consistent in how I've had other parents come to me and with very high conflicts and ask for homeschooling, and it's just not going to work. You guys cannot do that together. So you guys need him to go to a real school in person and both of you be able to participate equally in that and be able to, you can supplement that. Parents are the first teachers of their children, and both of you have the ability to supplement that and spend time with him, work with him on things like reading and all the things. You have to have a lot of benefits that you can provide to your son, but co-parenting is not one of the benefits you guys are able to do. So I have to make very detailed orders and hope that you guys can at least parallel parent him. That you guys have such different philosophies that you're going to have to do on your time what you think is best and what works with your philosophy, and she's going to do the same. And eventually you guys are going to have to go to a week-on, week-off schedule. I put the current schedule in place because of his age.
Okay.
But because of the high conflict and the best you guys can do, the more you guys try to agree on an extracurricular activity, the more you guys fight. The communications are horrible. You guys don't even, and don't exist in the same planet.
I agree.
Basically. And so you both love your child. You both, I believe, want what's best for him, and you both bring different strengths to the table. That's why you guys are sharing custody. There's nobody changing that, but you can't come and ask me to make second guess the decision on schooling when you didn't provide me the information up front. You two can agree on school. If you agree, we're going to change him from the current school, we agree, we're on the same page, you guys can do that. But I'm not going to do that today. And if you guys want to litigate again with everything you've litigated, how long this case was filed on December 12, 2019. I just entered the findings of fact and conclusion law and decree of custody on September 7th. That is entirely too long for you guys to be litigating a custody issue. It's supposed to be resolved in 6 months. Unfortunately, I didn't have control over that. You guys did, though, have some control over getting this. You guys can't see anything together. And I'm sorry that I have to micromanage your parenting.
I think that's best.
Micromanage your schedule so you guys don't have a power struggle over it. There's no other case I've had to enter a very specific order with dates on when you have summer vacation. Because you guys just can't even work that out. And then you took advantage of the fact that you went first and you took 3 extra days. So that's going to be made up to her.
Your Honor, in the
You did, sir, you did. There's no other way to count. Math is finite. The number of days you took exceeded 21 by 3 days. You took 24 days, and you guys do that. But I've set it up now so that you have Father's Day every year, and you guys are alternating who has 4th of July holiday with him. And you guys have adequate time for both of you to take good vacations with your son, enjoy that time, enjoy your families, your extended families. I've done the best I can do with the facts you guys have presented and where you guys are.
Okay.
Any other questions or clarifications?
I would just say, I took 23 days, and then she took 23 days also. I also lost Father's Day weekend.
And I find that, again, due to both of your miscommunication, because you could have started, you wanted to take advantage of your cake and eat it too. You wanted the Father's Day weekend and 21 days. You didn't get that, so you decided to tack on, and you knew she objected to that tacking. And I've entered a clear order now that there should be no fights. There's no need to negotiate anything. If you guys come to some agreement to change it, I'm not going to interfere with that. But if you don't have an agreement, you have a very clear order, and I'm going to make sure it's followed. And if somebody doesn't follow it, there'll be consequences. That's all I can do based on the facts of this case.
Okay.
Any other questions or clarifications, sir?
And you just, you don't think that the motion to modify merits an evidentiary hearing?
To modify the school?
Yes.
No, not at this time. No, you were given an opportunity to litigate that. I'm not changing it this year. If you want to file a new motion over next year, you should carefully consider that in terms of the issues of fees and stuff in this case, because you guys have both already litigated so much. But that is your prerogative to say we should change schools next year for X, Y, and Z reason. But you better comply with EDCR 5.501 and confer with her and her attorney about that first and try to work it out. You guys have options that you two can agree on. If you agree, I'm not going to come into your homes and interfere with your agreements. But if you can't agree, I have to make decisions that I think is in the best interest of your 5-year-old child. He'll be 6 soon.
Correct.
So
2 days.
and that's the best I can do. You guys should have already received by email. I just signed a new order. You should have received that in Mr. Schonfeld's order app or email, I'm sorry, and you should have received that by email too, sir.
Okay.
You have a new holiday and vacation plan that separate for both of you. Mr. Schonfeld, do you have any question or clarification of anything?
Your Honor, there's one issue that the court didn't expressly address, which was the allegation that committed perjury, or alternatively that I suborned perjury. And the reason I would like the court to address that is because the defendant has served me with an unfiled Rule 11 motion for sanctions that if he does file will be res judicata, and I will not only be filing a counter motion for fees, I will be seeking that he be deemed a vexatious litigant, as well as other relief in the counter motion. The issue related to claims that somehow she committed perjury because at her deposition she didn't recall having sent text messages that she was then impeached with because the text messages were inconsistent with her testimony. At trial, she testified saying that she didn't remember those text messages. The defendant, through his counsel, who was conducting the trial with him, had every opportunity to cross-examine related to the deposition testimony and the text messages. For someone to take the witness stand and explain why their testimony was previously inconsistent is not perjury. That's something that the court should welcome. And then they have the opportunity to cross-examine that witness and try to claim that somehow their credibility should be impeached. It is not suborning perjury, nor was it perjury testimony. She acknowledged that her prior testimony was inconsistent. So I would like the court to make a finding on that so that it is res judicata in the event that the Rule 11 motion is in fact filed.
I am making a finding that on both the allegations of the defendant, that plaintiff and that plaintiff's mother committed perjury have not been proven. There is no proof of that perjury. And you did get the opportunity as far as to cross-examine her and attack her credibility on the inconsistent testimony. That doesn't mean she committed perjury. I don't find that there's evidence of perjury in this case.
Okay.
Thank you, Your Honor.
And as to the Rule 11 motion, there were a couple more written statements, but I would agree that it's res judicata. I mean, at this time, I politely disagree with the outcome, but I agree that it's adjudicated.
I understand, sir. Any other, did that address them all?
Is it one other thing, Your Honor? You asked for a billing statement on the Brunzell fees
Yes.
declaration that I filed. Trying to save my client expenses, I charged a flat fee related to post-adjudication motion, so I will outline that in my affidavit, but there won't be a billing statement.
All right, there won't be hourly billing statement, but what justifies under Brunzell the flat fee you did charge?
I will outline hours worked on this. It's just not the billable rate.
Perfect.
Thank you, Your Honor.
All right, sir, you understand your deadline to respond to that, so I will make a decision, so you have to file a timely opposition.
Yes, I understand.
All right, thank you all. Mr. Schonfeld, I do need a findings of fact and clues on order on these, so we have a clear record here.
Thank you. Your Honor, one last issue, it's not part of this, but the FaceTime window that the court ordered in the decree was 6:30 to 9. Sorry, it was 8 to 9:30. Goes to sleep at 9. 8:30. So we were wanting to see if the court would consider making the window for FaceTime 6:30 to 9 p.m. as opposed to 9:30 p.m.
In this case, if I were to consider that issue today, I'd probably be inclined to eliminate it completely. It's just another thing for them to fight about. So I think I will make a ruling on changing, clarifying the FaceTime. I'm trying to eliminate issues that are a power struggle or fight over, and especially when you guys take him on a 3-week vacation, the other parent should be able to have video contact that's meaningful on that. But on the everyday week with the current schedule, maybe not. Maybe it's too much of a power struggle. Maybe it's too much stress on your child with everything going on. I will consider that, sir. So you can brief that issue if you want to brief what you think, short brief on what you think the order should be regarding FaceTime.
I think the current order is best and accurate. My issue is just that the FaceTimes never happened from when Miss has custody on time, and I just have no idea how to. I'm not going to come in here with a motion for an order to show cause every time a FaceTime is 20 minutes late, but when it's happening, like for example, she said that bedtime was 8 o'clock. The next day, she FaceTimed me with him at 9:47. you know, I don't know how to deal with something like that. I just assume that I'm never going to be able to FaceTime my kid, and that's just how it goes.
Your Honor, we will be seeking to vacate the order regarding FaceTime during non-holiday visitation schedules.
It might be easier, I don't know what's best here.
I
I
agree.
would love you guys to be able to just call your son when he's with the other parent and have free access. But everything is a power struggle. Literally, every little thing is a power struggle. I remember very vividly at the end of the trial, and I was trying to explain to you guys what stress you're putting your son under, and that he's going to end up dividing himself into two people, being one person at dad's house and one person at mom's house, because you guys are so at each other's throats, and the stress that puts a child under. He's too little to be able to navigate that. And I was trying to do that. And the first thing that came out of your mouth, sir, was, can you tell her not to let her son wear makeup? I remember that like you didn't even hear the words that were coming out of my mouth, and that you want to control. I'm not going to let either one of you control what goes on the other parent's home unless it regs to something that's abuse and neglect. I'm going to be very, very specific about that and try to get the conflict. I may not be able to get you to be on the same page and to hold hands and be friends and co-parents, but I can make you guys stop fighting by very clear orders that I have to make every decision in your case about what extracurricular activities your son attends. If I have to do everything, I will, for his benefit, because I'm going to take away the power struggle between the two of you. That's hurting your son.
Your Honor, the last issue, and I heard what the court just said, not ordering the other parent to do something during their time, but this one's medical. Nicholas was prescribed eye drops, and our understanding is that Mr. is not administering the eye drops during his custodial time.
May I respond?
I'm not going to allow you to respond today, just because I'm not going to make a decision today. I would like to see that in writing. If you guys want each have a right to do a 5-page supplemental brief before the October 13th hearing on any other parenting issues you want me to address at that hearing.
Okay.
Thank you, Your Honor.
I reserve the right to do that or not, whatever I find is in the best interest of the child. All right, thank you.
Thank you, Your Honor.
Thank you for your time.